are live. Good morning. My name is James Wood, one of the editors at the Legal 500, and it's my great pleasure to welcome you to our webinar today, IP and Brand Protection in the UAE. That's obviously not a very precise title, but as you see, we'll be exploring a number of issues surrounding the broad framework of brand protection and IP. Well, look, I'm sure it's a relief to many of you that we're not talking about COVID-19, at least not directly. It will actually come up in quite a significant way. But that's, I suppose, a sign that GCs are interested in hearing about actual legal topics right now. And it's a good sign that we have so many in the audience for this. So thank you for all joining us. Thank you all for joining us. A huge thank you to Rouse for partnering with us here. We'll hear from two members of the firm today, Basil Al-Turk and Samantha Granger, who will be giving us an overview of the trends and issues to watch in the IP space in the UAE. As I'm sure many of you know, Rouse is an IP services advisory network that provides a full range of intellectual property services from patent and trademark protection to management and commercialization, global enforcement, and anti-counterfeiting. We also have a consulting division that provides strategic and multidisciplinary consulting services to technology companies and brand owners globally. Although historically the firm's roots are in London, I believe, it focuses on emerging markets, or really, I guess, markets that have emerged over the past 2 decades. It now has a significant footprint outside the UK and Europe. So, for example, I think last year, I think I'm right, you opened an office in Shenzhen. That was your, I think, 5th office opening in China and 13th in the Asia Pacific region. So obviously a very exciting firm, one on a strong upward trajectory, and one that, if I may say, is also truly doing something different when it comes to IP advice. So we're very fortunate to have them on hand to delve into some of the idiosyncrasies of IP law in the UAE and the wider GCC. Thank you to Rouse. To guide us through the topics today, as I said, we will hear from, firstly, Basil Al-Turk, who is Principal and Country Manager of Rouse's UAE business. Basil joined Rouse in 2006 and heads its Dubai disputes team. He works on a range of IP matters in the firm's Dubai office, with particular focus on enforcement and complex IP litigation in the Middle East and North Africa. He manages the IP portfolios for a number of multinational entities across the Middle East and North Africa, as well as regional entities worldwide, and advises on potential legal and cultural risks associated with Arabic language marketing and advertising across the MENA region. I will ask Basil to introduce himself shortly, but just to introduce the rest of our panel today, we'll also hear from Samantha Granger. Samantha is a principal and legal consultant with Rouse in Dubai. Samantha joined Rouse's Dubai office in 1999 and was really, I believe, an instrumental figure in building its success in the market. She took a break from Rouse in 2007 to work for Tatweer Dubai LLC. That's the development company. I'm sure most of you know it. It's responsible for Dubai Land, Tiger Woods Dubai, Global Village, and Dubai Healthcare City. I'm sure many other developments. And while at Tatweer, she was responsible for negotiating, drafting, and advising on international licensing and franchising agreements, covering a wide spectrum of sectors for the maintenance and enforcement of the company's IP portfolio. You, I think it was 2010, is that correct, Samantha? She rejoined Rouse in 2010. Since then, she has advised on a wide range of licensing and franchising agreements, both regional, international, IP protection and enforcement. She is responsible for the management of enforcement actions of IP rights for major international companies in respect of fast-moving consumer goods and pharmaceuticals in North Africa, Middle East, and India. So 2 very good people to have on hand today. Thank you very much for joining us. I'll give brief introductions for the rest of the panel. So beyond Samantha and Basil, I'm very pleased to say we have an exceptional cast of speakers joining us today who will be taking us through the subject, sharing their experiences. Firstly, we have Dr. Tarek Hajiri. Dr. Tarek Hajiri is Senior Vice President Commissioner of Intellectual Property at Dubai International Financial Centre, DIFC. Again, I'm sure everyone in the audience, particularly in the UAE, knows DIFC very well, but for the benefit of international viewers, DIFC is a leading global financial centre in the Middle East, Africa, and South Asia. Dr. Hajiri was appointed as the DIFC's first Commissioner of Intellectual Property last year following the enactment of intellectual property law in 2019, the DIFC's intellectual property law. And that's a law that underscores the DIFC's commitment to applying international best practice to protect the intellectual property rights of businesses and ensure creativity and innovation thrives in both Dubai and the DIFC. As Commissioner of Intellectual Property, he works alongside the DIFC's entities to shape the development of the creative economy and enhance Dubai's position as a preferred destination for creative talent and entrepreneurship, which is something we will be discussing later. So very pleased to have him join us. Thank you very much, Dr. Hijiri. Yeah, also joined by Yossa Hamza of Gartner. Yossa is Director of Legal for Middle East at Gartner, the global research and advisory firm. She was responsible for establishing the company's first legal function when she joined in 2014 and has been described as smart, collaborative, proactive, and business-oriented. She was described as that by colleagues in our very own GC Power List for the Middle East. But it's not just the Legal 500 that's recognised her as an outstanding GC. She's won a number of awards and recognitions from a whole variety of business and legal titles. I won't embarrass her by heaping on any more praise, but we're very lucky to be joined by her. Thank you very much, Yossa, for joining us. We will also hear from Tarek Mogarabal. Apologies if I'm mispronouncing your name there, Tarek. Tarek is Executive Director and Senior Country Counsel for Middle East, North Africa, Pakistan and Turkey, as well as Senior Counsel for Luxembourg at JP Morgan Chase Bank. He's been with JP Morgan since 2012, where he is involved in supporting corporate and investment banking transactions. I believe, Tarek, you were JP Morgan's first lawyer in Dubai. I think I'm correct in saying that?
Yes, correct. Yeah.
Not there, thanks. Great. And you've since, he's since built out the legal function there, and also on the commercial side, he's been very much involved in the expansion projects the bank has had across the region, particularly in Saudi Arabia, I believe. So again, excellent person to have on board. Thank you very much, Tarek. Finally, last but not least, we will hear from Ali Khalaf of Evolence Group. Ali is the General Counsel of the Evolence Group. It's a Dubai-based conglomerate which focuses on asset management, education and retail. Ali assists the group on legal and compliance matters for all of its investment vehicles, divisions and portfolio entities. He's been with Evolvence since 2012 and was previously with Rasmala Investment Bank, a regional investment bank headquartered in Dubai. So someone who knows the Dubai financial investment scene inside out. He also brings US experience. Prior to moving to Dubai, he was at Jordan Burt Law Firm, Washington, DC. He's licensed to practice in the state of New York and is a member of the American Bar Association. So again, wonderful to have you here, Ali. Thank you very much for joining us. Just a very quick word on housekeeping from me before I pass over to Basil. It goes without saying that our speakers will be giving their views on the subject, and we're delighted to hear from them, but we also want to hear from you in the audience. So if you have any questions, comments, or any issues you want to see the panel discuss or get feedback on, please do so using the chat function. We'll be happy to answer your questions as and when we can. Okay, that's enough from me. With that, I will pass over to Basil. Basil, please.
Thank you very much, James. And I would like to thank Legal 500 for organizing this webinar and all the speakers that are joining and sharing their expertise. It is very important for us as IP practitioners always to hear from GCs and in-house counsel. IP as a function, a legal function that actually is highly impacted by commercial decisions, and it has an overlap on the commercial and business nature of any company. And therefore, the practicality of the legal decisions around intellectual property is very important, and you can mainly get this from general counsels who are working inside companies and look at things from that perspective. So thank you very much for inviting GCs into the panel. That's going to be a very important addition to our knowledge. As Rouse would like to introduce this webinar by mainly talking about intellectual property from a more macro perspective. And that's because of the changes that we've been seeing in global economies in general, and that have also been echoed with the needs that have been presented to us during the COVID crisis. in the business world, there are a lot of words that become trending for some years, like strategy 10 years ago was everyone in the business world was using the word strategy. The next word that has been really used so much and been trending after strategy for the past years is the word innovation. Every business mind will be talking about innovation, will have to include the word innovation in what he's talking about. And that's mainly because of what's happening with the global economies, and they're shifting from the conventional economies that we're used to non-conventional economies based on innovation and knowledge. UAE being one of the first countries in the region to capture that and to look into moving that economy, their economy, into innovation-based economies and knowledge-based economies. They've already put plans in place. They've already discussed the initiatives, and that's a very important transformation. What does that have to do with IP? Well, it has to do a lot with IP. And this is what we're trying to demonstrate through this webinar and this introduction. So what is really an innovation or a knowledge-based economy? It is economy that is mainly based on the production of knowledge. So if we say a conventional economy in the GCC is focused on the production of oil, just imagine removing the oil barrel and putting knowledge instead. So knowledge becomes the main element of production of the economy and the main element of the wealth creation, growth, and employment. So the knowledge itself being the product that the economy is exporting outside its borders means that they're attracting investments and into sectors that would produce that knowledge. This comes with a question on how do we attract these investments in order to build that economy. To understand that, we have to understand the three main elements of knowledge-based economies. The first being the knowledge itself, which is the intellectual capital of the economy, the actual asset that you have and building the economy on. So that intellectual asset is pretty much the IP value that you're trying to build the economy on. So you've got a lot of intellectual assets, intellectual capitals. Not all of them fall within the IP space because not all of them represent the property by themselves, but a lot of them do. And to be able to protect that asset as an intellectual capital, you need to have a proper foundation of intellectual property practice and laws. The second element of such economy is globalization. So what this economy does, a knowledge-based economy does, is it facilitates globalization. And I'm not talking about only by introducing technologies and communication. Definitely introducing technologies in communication is an aspect that assists a lot in globalization. But this is not the only reason why knowledge-based economies and technologies are major aspects of globalization. Actually, even any technology, even if it's not being applied to communication, if it's being applied to a certain production line, it's much easier for businesses and countries to export a technology than to actually export a product. A technology can travel around the world much faster than a product can travel around the world. So if we start developing technologies and selling them outside, we're harmonizing the way we produce, the way we live, the way we innovate. And this is where globalization actually rests. It's not because we're using the Zoom platform to be able to do that webinar only. So this is the second element of that economy and where technology is very important. The third element, and this is where us as lawyers need to be focused on, is the changes that this economy actually represents to the conventional way of looking at risks and uncertainty in the conventional economies. Knowledge-based economy is actually based on some level of uncertainty. So the risk element is much higher. And economists would look at it from that lens because that uncertainty um, and unpredictability within the economy is a main factor for how this economy is rapidly moving. Now, this is the main thing that we need to think about as lawyers. Given that these pillars would actually tell us that an inherent nature of that economy is that it's uncertain, how can we attract investors into investing in these economies? Investors would look at two aspects: the financial aspect of their investment. I think Ali would explain that more later on. So there's the financial element of that investment, but there's also the risk associated with that investment, and they need to balance those. Now, if we just openly say to investors that we're going into a knowledge-based economy that's actually built on uncertainty, that's not a very attractive proposition. And this is where us as IP lawyers and IP practitioners kick in. Given that we've said knowledge is the capital, the intellectual capital of this economy, then we will try to manage as much as we can the risks associated with the capital represented by intellectual property, rather than mitigating the risk in relation to the performance of what these technologies are gonna present. So therefore, in order to mitigate that risk, we need to present to investors that there's a proper platform in protecting and registering and securing the rights in the intellectual capital that is represented by these technologies. And this is primarily intellectual property laws and practices. And this is why in the UAE, we can see since 1992 until today, they've introduced laws and amended these laws several times to properly build and develop their intellectual property infrastructure. And as Dr. Tariq will be telling us today, there's a new IP law as well within the DIFC free zone that would also have a very big impact on building the certainty around the protection of such intellectual capital to attract further investments into innovation and knowledge. However, laws are not the only aspects and concerns that we're looking at. We know that the laws in the UAE are not bad. They're actually very good laws, and they're built on good precedents of laws across the globe. However, if these laws are not coined with proper practice, then the element of risk is still there. An investor would not only ask, what does the law say about this legal principle in relation to patents, for example, like obviousness. The investor would say, how does the court deal with this question? How do the IP experts deal with this question? Because this is the element of certainty that they would actually require. And this can only happen, especially in terms of complex IP questions, when we have a long-standing experience in applying these rules and regulations and legal principles in a court of law. Now, do we have that? We do for simpler IP questions, but we don't have enough precedent that would create that foundation and level of certainty in relation to more complex questions that are directly related to innovation and patenting and technologies. And therefore, the question that we would also later on would like to ask Dr. Tariq is, how can we apply that possibly within the IFC courts, for example, or apply something similar to what the IFC has done to the financial sector? We do something similar to the IP sector. And obviously, we will let Dr. Tariq to elaborate on that later on when he speaks about it. So therefore, now we know that at a macro level, economies are shifting into knowledge-based economies, and IP has become a major element of these economies. How did that actually impact businesses? Well, businesses within these economies have also realized that knowledge and innovation isn't actually in their everyday life. There's a lot of businesses today, actually IP practices today, seek to help their clients capture the innovation. So they don't only seek to help them to innovate or invest in innovation. Actually, we seek to help them capture this innovation, because a lot of companies have been innovating, or their employees have been innovating for so long, but no one is capturing that and realizing what kind of value is actually in there. A lot of companies have more than 75% of their asset value in intangible assets. And that presents the importance of intellectual property assets or intangible assets within these companies. And this is where companies need to start realizing that the protection of intellectual property, it's not always a cost base. Your IP teams within these companies are not always a cost base. They can actually be revenue generating departments and revenue generating arms of the business, because of the value in these assets that are first appreciating and can be actually invested in to generate further revenue. So it's important for businesses to rethink the way they do the budgets in relation to the protection of their intellectual property, maintenance of their intellectual property, utilization and commercialization of this property, and actually building teams that are capable of doing so to generate further revenue into the businesses. Now, this change in economies that have also reshaped businesses, the way they look at intellectual property, has also impacted the IP practice itself. So us as a law firm, and as James have said, that a few years ago, we've developed a consultancy arm. And that's primarily because we felt that based on the knowledge that we had and experience that we had on about intellectual property for the past decades, we can actually bank on this knowledge and try to help businesses understand intellectual property and intellectual assets more outside the scope of the conventional legal schemes of things, and how to try to align the business objectives of these companies with an IP strategy that would help them build new streams of revenue into the business. And as Dr. Hujairi would elaborate even further, there's a strategy where to separate your IP assets from the operation of the business to maximize value of your operations. So these are the kind of things that IP businesses today need to step up on the value chain, bank on all the knowledge they have in terms of legal and prosecution and protection, and step up on the value chain and be able to apply all of this in terms of providing proper and effective strategies for their clients to be able to build on. The other things that IP practices need to bank on now, given the importance of and prioritization of intellectual property today, is how to sell IP services to other law firms as a service. And this is where we become an IP services provider rather than just an IP law firm. So we know that IP now is a value associated with these companies, it's an asset associated with these companies. In bankruptcy procedures, we don't see in new bankruptcy procedures in the UAE IP lawyers being actually involved or joining forces with the bankruptcy lawyers in order to assist in evaluating the IP asset itself, or helping in in bankruptcy proceeding on how you can actually generate revenue to revive the company that have been subject to bankruptcy procedures. IP practitioners need to also join forces with the M&A lawyers and businesses at earlier stages. We know that they do, but they always come last. They need to come today at earlier stages, especially, and Ali would add more value to this, especially when there's a technology element to the M&A. There are a lot of labor disputes that involve IP. IP lawyers need to also to step in and join forces. And why do I ask for this? Because as I said, there's very little precedence in the court in terms of intellectual property cases. The question is, you don't need a pure intellectual property case to demonstrate IP practice and to add IP precedents. IP today overlaps with a lot of other areas. And if IP practitioners actually join forces with other arms of the legal field, then we will be building that expertise in courts and experts and across judges, because the IP field is being discussed in other types of cases. Now, having said that, we can definitely say that COVID and the crisis presented by COVID have echoed all of this to all of us. COVID have actually demonstrated how important these discussions that we've just had are. We've realized that the globalization element of a knowledge-based economy have actually made us closer to each other. With social distancing, actually with physical distancing, we mingled socially even more. I've spoken to friends during the lockdown that I haven't spoken to. I've seen them on videos I haven't spoken to in years. So it wasn't really a social distancing. It was pretty much a physical distancing, but we reconnected through technology because COVID pushed that technology onto us. So COVID have told us today more than any time before how important it is to innovate, how important it is to bank on technology, how important it is to protect intellectual property as the main foundation for us to be building the economies of the future. This is the macro impact of COVID, and I'll give Samantha the floor to discuss the more direct impact of COVID on intellectual property.
Thanks, Basil. I actually thought you were going to get through your whole presentation then without mentioning the word COVID, which what I've been quite impressed about. So as Basil's discussed, we need to brand owners need to get a platform to protect their technologies, and due to the pandemic, this has probably become more difficult. When budget was more relatively available to protect IP and enforce your rights, probably little questions were asked by your finance department or your procurement department about taking action. Unfortunately, the main impact of this pandemic has been financial. Brand owners' budgets have shrunk and consumers have less money. So brand owners need to think more than ever, and I'm going to use the word that was bandied around in the, did you say 80s, strategically about what they want to protect. Consumers have less money. This is a huge opportunity for an infringement. Consumers are looking to buy cheaper products but still want to look the same, and infringers can take advantages of this opportunity by offering a similar product which can infringe the IP. So it's a double-edged sword. The brand owners have less money, the consumers have less money, so you've got less money to deal with infringements and protection that you want to put in place. A strategy and the whole value chain, for want of a better word, needs to work together to tackle this issue. So we need a strategy from the government, brand owners, and also us as service providers. During the pandemic, in some governments have taken action. The UAE government have reduced official fees for filing trademark applications back in April with a view to sort of helping people be able to protect the IP that they have. Deadlines have been extended, and some governments have relaxed the rules around notarization and legalization. We found it a big problem for brand owners who were very keen to register applications, were unable to get powers of attorney legalized because of the closure of consulates around the world, and we worked with trademark offices in the region to come up with a system that we would be able to still file based either on a notarized copy or a signed power. Unfortunately, those have now dwindled off, and unless we go into a peak of the second wave of the COVID, those have now gone. So we're still now in a position of having to get notarized and legalized powers of attorney. The governments as well have strategized their enforcement activities against counterfeits. They're prioritizing action against sanitization products, masks and health and safety. And there has been reports, I'm sure, around the region where government authorities have seized hand sanitizer that doesn't live up to what it says it does, and also face masks that aren't doing the job that they should be doing. Service providers have also worked to help brand owners through these difficult times, offered discounts, made new arrangements for payments, extended payment terms, and have reshaped the way they bill. The majority of work that I do now is now done on a fixed and capped fee, and it's the most common way we bill. The brand owner has certainty on the fee that they're going to get charged, which then they can make sure their budgets are managed correctly. I think going forward, for however long this goes, and I think taking a 5-year view is probably a wise decision, is that the service providers need to move up the value chain with the brand owners to devise strategies to deal with the increasing problem of IP infringement with less resource that they have. Consideration should be given to IP audits for the next 5 years to see where money can be saved, and also processes put in place within the company as to when action should be taken or brands protected. This cuts down on a lot of back and forth as to, say, for example, in relation to an enforcement action, getting do we take action? There's a clear set of guidelines as to when a company should consider taking action. It can sort of result in a lot of discussion and produce a more streamlined, efficient approach. Likewise, if then a decision is taken to take action, making sure all the documents are in together, packaged and ready to go. Wasted costs can be incurred where we're, all scrabbling around for trademark registration certificates, examples of the original, and all sorts of things like that. Make sure the trademark registrations are kept together, up to date with the renewals, and documents are sort of easily found. Other things like images of genuine products and trademark registrations, I've said, and details on how to identify counterfeits as well. A standard sheet as to, how easy, what are those distinguishing factors that would make something counterfeit. I know sometimes that's not easy, particularly in the medical space, but there's usually something on the packaging that can be shown that the product is counterfeit, and obviously is usually confidential. Brand owners and GCs need to think strategically, about what we're going to register in the future. My advice to clients is generally, your IP strategy and your platform, as Basil said, should follow your business plan. You should work closely with your business partners to see what they're doing and, align an intellectual property strategy to follow that business plan and that business development. I've worked in-house, and sometimes you'll only know about a deal when the actual agreement lands on your desk and they want it turned around within 6 hours and signed by tomorrow. You've got to think about the strategy, the IP. Has that other person got their trademark rights registered, or the technology they're licensing? What protection in place is there? So I think for GCs, you need to get into those deals and at a very early stage to make sure that that strategy aligns with what you can do legally, because if you have an agreement, there's nothing you can do to enforce it, or from a legal point of view, then what is the value? What could it be argued, what is the value in it? I think that given now that the legal and strategy plays such an important part in protecting and enforcing companies' intangible assets, so as I mentioned previously, it's a good time to take a review. The the value in them can be huge, and the leverage that is available on them is something that could help companies financially, being as that is the major impact we're having at the moment with finances, for a company to keep its sort of place in where it wants to be. So I think my takeaway message really is for GCs is to get involved right at the very beginning with various aspects of the business, when deals are done, marketing, so what's going on, and you can preempt what's coming in order that you can strategize effectively and efficiently down the line. And I'll hand back to James now, I think.
Excellent, thank you very much. So two very fascinating statements there to set us up for discussion. I mean, Samantha's speech outlined some of the strategies, there's that word again, some of the strategies brand owners and GCs can and should follow to protect the value of their assets. And I'd be very interested to hear the GCs that have joined us today, to hear their views on that. But first, I'm going to kind of return to some elements of Basil's introduction on the significance and consequences of the transition to a knowledge-based economy, or an innovation-based economy, to use another buzzword. And one thing that came out of that was the significance of some of the work the DIFC is doing. And as I said before, we are fortunately joined by Dr. Tarek Hajiri of the DIFC. So Dr. Hajiri, could you kind of give us an overview of the new IP law that was passed by the DIFC the back end of last year, early this year, and its significance?
Yeah, sure. Thank you very much, James. First of all, I thank you for inviting me to be with this such distinguished panelists and to speak about IP, which is I'm very passionate to it as an IP lawyer as I started my career. And to be honest, intellectual property, and of course, as Basil stated also in his introduction, I echo what he said, and I believe that protection of the intellectual property of any investment or any business is the heart of your business. It's exactly like building a tower with a very strong foundation. So it all depends on intellectual property, because this is the asset. This is your business. So for us in the IFC and for I'm sure that maybe most of our audience are aware of our, Dubai International Financial Center as a free zone. We thought of that we need to complement our, of course, legal infrastructure and to produce a very innovative law that protects and complement our legal structure and ecosystem in the IFC. So we came up with DIFC Law Number 4 of 2019 as a one comprehensive law that tackles all types of intellectual property, unlike let's say onshore, where you have a specific law for copyrights or patents or trademarks. So we have one law that covers all laws. And of course, we have done something which is very important, and actually as before we joined online, we were discussing what we have done to be aligned with our UAE legal structure is that we recognize the federal law as initial and as a first start for us. So we were very keen to be very friendly use and friendly law for all our users. So what we have done is we improved and we enhanced the IP laws in the IFC, but we recognize the registration of the IP in the United Arab Emirates. So any brand owner who registered his or their trademark or copyright or patent is recognized within the IFC. And of course, protected based on that. We do not actually require any registration, so there is we reduce the burden on the investment itself. We actually of course also keen to be very and full compliant with the IP international treaties. Same like, you know, most of course, the IP laws, that it has to be assured. We made sure to produce a very flexible enforcement of IP rights. Like, you know, as you know, and as we have just discussed, that IP owners in the traditional manner, or usually they focus on, or as an IP owner, let's say, sometimes, you know, they focus on the protection and enforcement. But for us as the IFC, we were very, you know, keen to have a law that works very smoothly with our other laws. So we end up with an ecosystem that works perfectly for the IP owner, from, let's say, registration to, let's say, protection, exploitation, enforcement, dispute settlement. We have actually an ecosystem that work for IP owners, whether they want to exploit their law for, let's say, access to finance, how they can do that, how they can utilize special vehicles, trust system, foundation, all this. So it's a full, actually, at the end of the day, we have an ecosystem that works perfectly for the IP owners. Now, to be honest, the law itself created some kind of administration which is the IP commissioner, and this is actually what I was honored to be appointed a few months ago, where I have the role to administer and to enforce the law itself, and actually to have a very quick, very flexible mechanism or way of making sure to ensure that all IP rights are protected, and of course the system that works perfectly. Of course, also we have the implemented a very important also element, which is the administrative fines. That, you know, we have fines that will be a very you know, role to prevent, actually, and we are aiming to have zero infringement in the IFC. So for us, our success is through public awareness, through actually having everybody knows what exactly the law is and how you can protect your rights, is we are aiming to have a zero infringement within our jurisdictions. And of course, for the GCs that, you know, that most of them, I believe they know that our DIFC courts, it's a common law system. So we are, and in the IFC, it's a common law jurisdiction. So we actually produce a very important also element in the law itself, or a change, which is that, you know, we have injunctive reliefs. The damages actually is completely different from other jurisdictions, so it's within actually and comply with the common law system. So as I said before, you know, we have tried to enhance also the law itself, or the IP rights. For example, like, you know, we built it on, let's say, the recognition of the IP rights registered in the UAE, but also we have amended, or we have improved, let's say, the copyright ownership relationship between employer and employee. We made it very clear and in line with, let's say, international standards and common law system. The assignment, let's say, of the future copyrights, the ownership of inventions, the employer-employee relationship, because this is extremely important for innovation and for actually for stability, you know, that, you know, for you as an investor, as the employer, you are aware of your rights, and the employees are aware of also their rights. So we have actually made a complete shift in some principles, where we implemented the infringement, let's say, test, where we implemented the doctrine of equivalence rather than, you know, the literal infringement tests. the contributory infringement, where you have inducers or like, some kind of cooperation from other, let's say, infringers. So it is very clear, and these are actually all tackled within our IP law. The infringement of a process of manufacturing, the reversal of the burden of evidence, for example. This is extremely also important. The suspension of patent infringement procedures. Let's say the well-known trademarks, the elements of considering this is well-known or not a well-known trademark. Trademark license. We have organized and regulated the relationship between the licensor and licensee, and the importance also the rights given to the licensee, where in onshore, let's say, they have very limited or restricted rights, like limited for, let's say, compensation, where we have given them the right also to file a case against the infringers. The fair use. We have actually identified very important also protection for trademark trade name, as you guys know, that how much these issues are also kind of confusing. The trade secrets, in onshore, there's till today there is no trade secret law for us. We have actually covered trade secrets, which is extremely important for innovation and for investors or for IP owners, that they prefer not to register their rights, but also to keep it as confidential. So actually, in a nutshell, what we have done is that we try to get a very flexible IP law that really works in a very friendly manner with IP investors, but also can be utilized for investors, and especially nowadays, to be honest, where companies, they try to look at, let's say, a very cost efficiency legal system where it is not expensive. So in order to protect your rights, you don't have to register it with us and to, let's say, to incur any more costs on yourself. It's your rights are recognized. Whether it's through registration or well-known or international actually treaties. The second thing is that we have a system where our judicial system is actually a common law-based system. So most of the international owners or IP owners will be familiar and also would like to have their or to establish, let's say, their holding company. And that's actually one of the things that we were discussing even before we go online, is that what we are now experiencing is that IP owners would, especially entrepreneurs or startups, startups, they have, and depend on their vision, they have, the best thing for them as an advice is that we as legal advisors or GCs to provide them with options, that based on your vision, it depends on your investment. So when you actually own your IP asset through a vehicle where you can have, as a holding company, you can actually separate between ownership, let's say, of the assets or operational of your business, then you're actually doing kind of risk mitigation that really will be very helpful. So at the end of the day, for us in the IFC, we created and we complemented an ecosystem, that really will work for and with the investors or IP owners in the manner that they, at the end of the day, they will be the best platform that they might actually have.
Excellent, thank you very much. Before I move on to the rest of the panel, I just remind those of you in the audience to submit questions through either the chat function or the Q&A. I know I can see a few hands, a few people have raised hands, but it's probably easier if you ask questions using the Q&A box. And as with any new law, there's obviously elements that the Dubai legal community wants to explore further. So this is a good opportunity to ask about the DIFC's new laws. So please do that. And again, before I move on to the rest of the panel, I want to turn to Basil, because just before we came on, you had asked a rather interesting question to Dr. Hajiri. We didn't get to hear the answer as we had to go live, but it's a question that I guess will be of interest to the audience. So can I ask you, for the audience and also so I can hear the answer that Dr. Hajiri was about to give, can I ask you to summarize and repeat your question, please?
Yeah, thank you very much, James, and thank you Dr. Tariq answered part of the question already in his words. So I'll give an example to make it easier. Now we have IP laws onshore, and we have IP laws in the DIFC that recognizes the rights that have been developed under the IP laws onshore. Now, but we also operate within a federal system. So with federal courts operating in Abu Dhabi and some other Emirates, but at the federal level, and local courts operating at Emirates level in some other Emirates. And we do have a free zone court, DIFC court within the free zone. Now, the question is not really in relation to the realization of the rights themselves. It's just the complexity of the court system. Let's now say that someone owns, like has registered patent. The patent is granted at a federal level, and therefore challenging the patent as a right is something that is most likely be done before a federal court, because we're challenging the patent as a right itself. However, if I was infringing the patent in Dubai, then Dubai courts would have jurisdiction to looking into that infringement. Now, there's an extra element of complexity here. If one of the parties is based in the DIFC, and the court laws in the DIFC says that if one of the parties is based within the DIFC, that also gives jurisdiction to the DIFC courts. That's in general, not in relation to IP, it's just in general that the court procedures in the DIFC says so. So the question is, when a DIFC party owns a patent at the federal level that was infringed in Dubai, there's that complexity of the court jurisdiction. And let's say we've chosen DIFC, and I've raised the infringement case in DIFC. There's a right of the alleged infringer to challenge my patent in defense, saying your patent is not patentable, it's not protectable, and therefore it needs to be cancelled as a defense, as a counterclaim. Would he be able to bring this counterclaim before the same court looking into the infringement, which is DIFC, or will have to go to the federal court and bring it because it's a federal law that's being cancelled? And if so, would the DIFC stay proceedings until the result of the cancellation proceedings or not?
Well, thank you very much, Basil. To be honest, yes, and that's actually what we have done, and we have clarified that as per the IP law, actually, the law provides the judge the discretion to suspend the patent infringement procedures, staying a decision in the invalidation claim by the competent court. So what really happens, it's a very flexible, because this is something definitely we might face, and this is something that it might happen. And this is, as you just said, this is actually the very traditional normal defense. You know, you try to invalidate your patent, or let's say trademark, or so this is something, yes, that it can be done. And just to reconfirm that any decision that is issued by the DIFC courts is enforceable also outside the jurisdiction of the DIFC.
Excellent, thank you. Just take a single question from the audience at this stage because it's relevant. So someone has asked, if a trademark is registered within the UAE, is there then no need to register it in the DIFC? Will it also still be protected by DIFC laws if it's not separately registered? That's correct. Okay, excellent, great, thank you. A reminder, keep questions coming in, please. We'll try to get around to as many of them as possible. Okay, I'm going to move on now and ask Yossa Hamza of Gartner to join us. Yossa, are you there?
Yep, I am.
Hi, thank you very much for joining us. I guess, look, I mean, Gartner has a huge IP portfolio. There's a lot of innovative work, and you're right at the front of that is GC. So just to start before I get to questions, can you just give us a sense of your role as GC in capturing and protecting some of that innovation?
Sure. I think in Gartner, every person in their own jurisdiction, we're taking a much more broad manner in how we protect the IP, because Gartner's assets, as Basil shared, is It's not about the tangible assets as much as the knowledge base and the research that we produce across the globe, and the researchers who develop that research. So we take it in a much more broader manner, because eventually we don't only develop research, we also go, and every year we rate all the companies who develop IP eventually. So Gartner really takes a very broad manner from our legal function to ensure that we don't only protect IP, but we also are fair and consistent. We protect our brand name, not only from a trademark perspective, but also from objectivity and independence viewpoint. So every time we have an IP infringement case, or I would say complaint, we always look from it from a perspective of unbiased. What did the client is claiming? Is an IP case worth it? Or how we can mutually negotiate with the client, how we can sort it out in a much more confidential basis. No one really has to know, but how we can also treat that from a fair, unbiased perspective to ensure that Gartner's brand name remains objective and independent across the market globally. That's maybe from our role perspective. We don't really consider ourselves a legal advisors as much as business advisors who ensure that to protect the brand name of the company on a much more broader scale.
Okay, excellent. I mean, look, we've raised the subject of COVID a couple of times in this in previous presentations. I mean, how has the value of your assets kind of held up during the pandemic? I mean, has there been a big impact there?
I would say our value definitely raised so much high. Clients appreciate the knowledge very much. However, I think the challenge that we have is that with COVID, as Samantha raised, is that a lot of the clients are having now a lot of budget cuts. So we're seeing much more cases of clients breaching the intellectual property of the research, sharing the research, sharing the licenses, and how we manage that it's very difficult. I think unlike maybe other companies, our IP budget has increased, and we're definitely seeking to impose IP cases more than we used in the past. So in fact, COVID has imposed on Gartner to increase the budget on IP rather than maybe unlike other companies. It showcased to the operating committee level how important IP is, how important the IP legal budget is, and how important we invest in systems and invest in local budgets to ensure that this is being enforced, unlike how we used to enforce it in the past.
That's interesting. So it's actually more of a focus on IP following COVID.
Yes. Yeah.
We're very pleased to hear that. Just kind of delving into, I suppose, the ins and outs of your job. I mean, look, one of the issues you have to contend with is enforcing IP rights against employees and researchers, or against clients. I mean, what are the issues you face there?
I would say we definitely face a couple of issues in my jurisdiction, and I'm sure every jurisdiction is different. But one of the issues I personally face in my jurisdiction is that how I protect my IP and copyright versus the employees who develop that. How I'm going to register the research it's being developed in every country, and how to manage that in a much more timely manner. And that raises the difficulty of I would say the inconsistent laws that we have across the jurisdictions that we cover. Every country has way much different laws and way much different enforcement and registration processes. And that also brings me to one different aspect, is that the laws are way much outdated than how we operate as a research company. There's that room with our clients who always feel that we provide them with a consultancy-based service, and accordingly they always push to own the research that we develop. However, how we enforce and audit our clients and how the laws are developed in that manner is definitely way much behind from how we operate as a research subscription company. And we have to always tackle and find a workaround in every case, and it's always dealt on a case-by-case basis. I think one of the things I always struggle with, and I think maybe with COVID, it's definitely way much easier, is that how I manage my legal budget from an IP perspective with my external counsels. It depends definitely on the complexity of every matter and the client that I'm dealing with. If it's government, I always have to really bring someone on board who is very focused, very market practice, but if they also have the relationships to manage that from a client perspective, because it's very it's very delicate when you deal with a government client who's breaching IP. But if you're dealing with a private client, that it's definitely from a different perspective. I always look from a responsiveness perspective, someone who knows the market very well, because eventually, as I said, is the laws doesn't really sometimes match how the market looks like as well. The market practice is in many ways is different. Every company is registered in whether it's a free zone or non-free zone, and whether they're outside, which emirate they're registered in. It also makes the difference for me on which court I'm going to raise the claim with as well.
So will the new DIFC laws that Dr. Hajiri was discussing, will they help in this regard?
Yes,
definitely, of course.
I would urge her to move to the IFC.
That is something we have been considering. I think with the DIFC court system is one of the most efficient court systems that we've been using so far. Not only on IP, by the way, IP perspective, but also from enforcement and collection perspective. It's definitely more efficient, more cost effective. It's something between the arbitration, but also the court system. I would say it's one of the most court systems we use, both in UAE and outside UAE as well, with clients outside. I think the most important thing we're talking about is the human factor and the trust that we have to build with the clients. Eventually there is a room that we have to trust our clients on how they're using our IP, our research, and we don't audit them like on a frequent basis. You don't go to the client premises and show me your computer, whether you deleted the research or not. There's the human factor that you have to consider in all of the IP enforcements that we're talking about, and that kind of human factor will always remain regardless of the legal system you operate in.
Excellent, great, thanks. Look, I'm sure Basil and Samantha will also have questions for you, but I'm going to move on briefly to Ali of Evolvance. Ali, hi. This, I guess, my first question to you kind of emanates from Basil's introduction and his overview of the legal consequences of a knowledge-based economy. I mean, you manage a portfolio that includes tech along with, I suppose, more traditional or less tech-heavy assets. I mean, do you see more risk in more disruptive assets? So one of the themes of Basil's introduction was the risk that comes with these innovative assets that would be more risky.
Yeah, so this asset class is different than if we were to invest, say, like in a series of restaurants, or invest in something more brick and mortar, not tech reliant. A lot of and this blends it. So as you know, we have education platform that we operate, and we also have our private equity investments. And what I'm finding is that I'm dedicating a lot more resources to my IP and tech and data security diligence exercises. It used to be that when we would vet certain companies, I'm talking 10 years ago, so no disrespect to the entire community, we would maybe look at it as an afterthought, allocate some last minute resources to bring in an IP specialist to just make sure that the nuts and bolts are there. And now it is paramount, not just with our tech investments, with any entity that has any reliance on its tech capabilities, whether it's licensed or organic. And so we factor this in. So if I look at an entity that hasn't ascribed any of its resources to protecting its IP or cybersecurity, data protection, then that's an impact and an adjustment on the valuation mechanism, right? So whatever multiple I've ascribed to it, I'm reducing it unless they get it up and running before we actually make the investment. So it's sometimes a condition subsequent. And so that is something we found has become the top of our issues in the last, say, 3 or 4 years. When evaluating our potential investments.
Excellent. And sorry, I forgive me if this is a sort of naive or reductive question, but as a private equity, essentially private equity investor, I mean, do the issues and concerns you have when it comes to IP, do they differ greatly from those of a strategic? I mean, are you looking at different things when you scrutinize?
Yeah. So I think when you mean strategic, if you mean when we're operating our own entity, not just sitting sort of as board advisors or portfolio investors. And so in my education platform, I am essentially a licensee of a very big series of UK education platforms, and so I derive significant amount of the value of my entity and my education platform from licenses. And if these aren't properly registered across the board from the licensors, sort of level to how I register them here. And I saw there was a question in the Q&A about how difficult it is to get your, all the, not just the trademarks, not just trade secrets now, but even certain patent technology that a lot of education platforms don't know that they sit on, or when we tailor certain intellectual property to address KHDA requests, ADIC requests in our education platform, it's a whole different world than when I'm vetting my potential investments. I have to make sure that any detrimental impact on whether a parent says something about the brand, about the education company, the license that we operate, that can have immediate degradation of value of our operations. So we're very mindful of making sure all the belts and braces are tight in our operations. Right? I'm a bit more lenient with my portfolio investments, is what I'm trying to say.
Okay, great, excellent. There was a question that Basil raised earlier, but I'll come to that in a second. Before I do, I'll just move on to Tarek. Tarek of JP Morgan. Hi, Tarek, thanks for joining us.
Hi. Hi, thank you.
Look, I don't know if you want to add anything from the introduction I gave you, but one of the questions I had is Yossa introduced the subject of, I suppose, perceived inconsistencies in the nature of IP laws across the region, the mismatch between outdated IP laws and some of the innovation taking place in businesses. But look, I mean, in your role, you're responsible for a huge range of markets, right up to Luxembourg, right? But including Pakistan, across the Middle East. I mean, what are some of the challenges you face then in trying to come up with an IP strategy there, particularly at a global business that has to have a unified approach to these matters?
Yeah. No, thank you. I think it's going back to the point that was mentioned earlier by Basil, how due to the globalization, technology moves faster than the goods and the commodities. So with that also, I think comes the challenges of having to protect these IP rights linked to the technology and other products on a global level, and not linked or limited to the jurisdictions that you are operating from. So from that perspective, as you mentioned, we cover out of in the region several jurisdictions, and where we do have offices, or we operate with or deal with clients and vendors, etc. So I think the challenge there is to find the right partners in these jurisdictions to understand the framework, and at the same time to protect our rights and our partners' rights, but at the same time also to try and protect against any infringement of these IP rights in these jurisdictions, and therefore having the right partner, as mentioned also by Yusr earlier, that not only can advise you on the what the law and regulation says, but at the same time how things are done in practice, how what's the best strategy to protect your rights in that specific jurisdiction. I think that would be key as well.
Excellent. Okay, great. Has COVID had much of an impact on your approach to IP?
I think probably with COVID more it's relating to the practical aspect. So with probably employees working from home, for example, you would tend to be more conscious about their need to protect against IP infringements, and therefore I think having the right legal framework is important. And going back to Dr. Tariq's point about how trade secrets now, for example, are being introduced in the IP law, the DIFC IP law. So if we're operating from the DIFC, then employees would be technically subject to these requirements, in addition to other requirements that they would be subject to in their employment agreements. But I think what is key as well is, in addition to the law and protections granted by the law, is the human factor, and the fact that having the right policies and the culture in place. I think this is important, because this is the preventative measure that comes, in my view, before the enforcement and trying to enforce the laws and contractual rights.
Okay, excellent, great. Look, thank you very much. I'm going to open it up for discussion. I'm sure Basil and Samantha have questions for the GCs, but one question I wanted to ask you, Basil, is this notion of IP assets being used as collateral for business loans. This is something you've touched upon and explored. Do you want to give us a kind of exposition of why this is important, and perhaps then we'll get some of the GC's thoughts on it?
Yes, first of all, we'd like to apologize that we were dropped off the call because of
I didn't want to mention it. Yeah, I wondered why.
So we're sharing a screen after, and we had to go for a while because we had to do the PCR test to sit next to each other. Yeah, so in terms of IP assets being used as collaterals, it's that has been pretty much introduced into the financial sector some years ago, but very lately, I think around 2 years ago, HSBC, along with an online IP tool called Ingot, have joined forces to be able to evaluate IP properly for it to be used as a collateral for business loans. Now, there's a lot of boxes that you would need to take. It's not as simple as that. You don't just do a trademark and go there and say, give me $100,000 for that. There's a lot of other boxes. There's a lot of regulations. It's still a very regulated and controlled area, but that's a very important jump. We know that it happened in the past, but it wasn't regulated by the banks. So the bank didn't actually banks didn't put procedures for these types of loans and collaterals. Now we can see that it's being introduced as a new kind of collateral, which adds much more value to how you can utilize your IP. Now, we've known for decades that you can, because of the laws, that you can mortgage your IP. So you can actually bank on the value of IP by mortgaging it, because laws do allow for that. We haven't really seen that in practice for the longest time. Now HSBC has introduced this, and I think more banks would follow. The important thing about this is not only the procedure itself, where you can go and bank on your IP from a bank. It's actually the result and the impact of this on the wealth of companies. Now, we understand if this is capable of happening, it means that if companies are being declared bankrupt, but they still sit on a big IP portfolio, that there's something to be done with this portfolio. You can revive this company by banking on its IP. You can go to a bank before you declare bankruptcy, say, I've got this. You can give me a loan and I can inject more cash into my business in order to revive my business. Whether this being done as part of the bankruptcy procedures or as part of the business to avoid bankruptcy, that's another question, but that's a very important development. And now, given that COVID have possibly resulted in a lot of bankruptcy procedures, it's something that companies need to look at seriously and see whether their IP is going to save them.
Okay, so IP as a way of unlocking funds for businesses or protecting them. And I guess this is also significant in M&A deals, right? IP being used as an asset in M&A transactions. Is that something that's becoming more important in the market?
Yeah, I think M&A. So there's two types of M&A deals. So there are M&A deals who are mainly focused on technology, where IP comes first.
Yeah, sure.
and there are the M&A deals where an example of that would be Uber and Careem, for example. That's a very technology-focused M&A, and most of the procedures and the advice around this deal have been made outside the UAE, although it included UAE-based company, but because of the expertise needed in the technology itself and in the field itself, it was made primarily outside the UAE. And there are other M&A deals that have IP as small aspects too. During my very early years of practicing, when I was still in Lebanon, I was working, it's not really an M&A deal, it was pretty much two brothers who had a photo shop that they wanted to sell each other the shares. So my brother wanted to acquire the shares of his other brother. And when they came to me as a trainee lawyer, they said, we want to do this deal. And when I looked at the contract, it was a very primitive contract saying, okay, so that shop is located in X location. This is the real estate value. This is how much we generate revenue. And therefore, I'll pay you $1 million. There was no mention whatsoever to the value of the brand that they're actually selling. So when we got auditors on the deal, and we asked them to evaluate the brand itself, the number jumped from $1 million to $2 million overnight. Now that's a very small deal, but that explains how much we miss out on IP angles when we do these deals. But now we can see that there's much more awareness, especially when we have private equity companies and funds like Ali's, for example, where they are much more mature and aware of the IP value, and their practice in the market would introduce that awareness to others.
Okay, excellent. Thank you. Ali, can I get your thoughts on this? Because as Basil just said, you invest in tech companies that rely on IP. I mean, have you assigned revenues from those vehicles? Is that something you've looked at?
Precisely. So times it's another carrot in my, or another stick in our bag to provide to banks in our security packages. If I have, let's say I have one of my investments is an operator of any good or service, and it also licenses some of its technology, right? Or so its trademark or any other item it's able to license and generate revenue from, then I'll have that most likely put that into its own vehicle and be able to provide an assignment of revenues, pledge of shares. We've actually done that in BVI entities that hold some of our IPs. So it's a growing fad. Banks take significant comfort because there's regular revenue coming in from that licensing of technology or a trademark. So we've seen practical usage of this.
Okay, excellent, thank you. And Yosser or Tarek, or indeed Dr. Khajiri, I don't know if you have any thoughts or experiences on these trends, anything that you're seeing in your day-to-day role that kind of touches on these issues.
Yes, actually I was muted, that's why, sorry.
Yeah.
Yes, actually, from what we have just listened is actually, and I would like to reiterate and to what I have said before, is that the importance that the IFC IP law will cover, as we have just heard, the employer-employee relationship. Let's say how the legal certainty is important between on these things, and the investment, the licensor, licensee, as Ali also just said, like most of the business that they also deal with is licenses. So the IP law covers and protects the licensee and is not reliant only on the licensor whether to take action or not. So this is something very important. And to be honest, as it is a new law, I would, and frankly, and it will definitely help, private equities or investors, IP owners, and I would urge, to be honest, everyone to be utilizing our ecosystem, our platform, to establish these vehicles where they can unify their investment under one umbrella and to be able to license or to sub-license, to invest, to have access to finance, to use as a collateral. So to be honest, is that what we have just heard confirms the importance of having a new IP law in the IFC.
Excellent, great, thank you very much. I'll take some questions from the audience briefly, because I'm conscious of time, but a reminder to Basil or Samantha, if you have any further questions or points to the audience or things you think are important to raise, please do. But questions from the audience, I'll try to interpret these and reword them. Quite brief. But
sorry, James, but I might need to leave in maybe 2 minutes because
okay,
I have
we'll keep it brief. But if you can hang on for these questions. So
sorry for that.
Can a trademark registered in the UAE benefit from international protection? And if yes, then what is the process for this? So does a trademark in the UAE, does it benefit from international protection? Sorry, Samantha, your feed's a bit crackly. Can you repeat that?
So if you register in the UAE, it would be only protected in the UAE. There are exceptions to that if it could be seen as a famous mark, but generally trademark registrations are territorial. There are various mechanisms around the world, such as OP, Madrid, Europe, where you can register for a number of countries. But at the moment, there's nothing for the GCC that would say protect a GCC trademark. There is for the patent, you can file a GCC patent, but at the moment in this region, it is territorial. So a UAE mark would only be, registration would only be protected in the UAE unless there was some other ground, such as fame.
Excellent, thanks. And a follow-up question, Samantha, that you may be able to address from the same person, Abir El-Tuhami. So COVID-19 has led to a lot of IP infringement cases, for example, trademarks, but is this only for non-registered trademarks? Is that correct? Is it only non-registered trademarks that are being infringed increasingly, or are we seeing the same with registered trademarks?
No, I think across the board, a lot of products are very close. I think very close to infringement. A lot of that out there. I don't necessarily. Obviously, I might have a registration.
Sorry, Samantha, I'm being told by a panelist that, well, by someone in the chat that they can't hear you. I can hear you perfectly, but I don't know.
Okay.
Yeah, we can hear you. Well, I can hear you.
Is that better? Sorry, I'm perhaps a bit away far from the mic. So basically, I don't think there's a clear division. I think there's some things out there that sail very close to the wind. If you go to an Aldi supermarket, for example, there's some, I always, I'm amazed sometimes to get away with this. But yeah, I don't think there's a clear division. But what I would say is if you have a registration, it's generally a lot easier to enforce in this part of the region because you can go to government administrative departments. If you don't have anything registered, it's usually a case for the courts or warning and letters, cease and desist letters.
Okay, great. And I'm pleased to hear that an IP lawyer is also snookered and confused by how discount supermarkets get away with what looks like a clear case of brand infringement. It's always confused me. I'm glad to hear that I'm not the only one. Great. Look, apologies, but I think we will have to leave it there in the interest of time. And also, Dr. Hajiri needs to leave urgently. So very finally, I will ask if Basil or Samantha have any final comments.
Not really comment. I just want to add to what Dr. Hajiri was saying about the new aspects of the IP law and to relate that to what Yusr has been facing in terms of slightly underdeveloped legal principles, especially in terms of copyright. And Dr. Hajiri has made it clear that they've closely looked at improving the licensing of future rights. The UAE laws have struggled previously in terms of assignment of future rights in terms of copyright, and they have limited it under the law to 5 future rights, which actually means that if I want to take from an employee in my business an assignment for the work that he does for me, and that would be limited to the 5 future rights or 5 future pieces that he would create for me during his employment. Today, before I got to this call, I've created more than 5 works myself. By first writing my notes on this presentation was one of those. There are like 3 other emails and a WhatsApp message. All of these are protected with copyright in a way because I created them. Now the question is, how would you be able to capture everything that an employee would do related to your business if the law only says that you're allowed to license or actually assign back 5 future rights? Now the DIFC have, and what's the basis of the number 5? There is no basis of the number 5 legally. No one knows where it came from, but the DIFC have cleared that today with the new law, and therefore it's much easier today to have certainty on who owns copyright and what in a relationship, whether it's an employment relationship or it's an assignment that you give for third party to create something for you.
True.
Thank you. Ringing endorsements there, Dr. Hejiri. So keep up the good work. Look, we'll have to leave it there. It would have been nice to hear more from the panel, but apologies in the interest of time, we have to cut it. But look, thank you very much to Ali Khalaf of Evolvent, to, of course, Dr. Tarek Hejiri of the DIFC, to Tarek Mogharbel of JP Morgan, to Yossa Hamza of Gartner, and of course to Basil Al-Turk and Samantha from Rouse. Thank you very much, and thanks to Rouse for supporting it. If there are any other questions, anyone has any follow-up questions, I'm sure Basil and Samantha will be pleased to answer them if they email them to you. I guess that's correct. I don't want to speak on your behalf, guys. Okay, cool. Excellent. Look, thank you all very much for joining us, and I'll leave it there. Thank you. Bye.
Thank you.
Thank you. Thank you.
Thank you.
Thank you.